Alrighty, this week's lecture is Chapter 9 in the textbook. It's called Punishment and Sentencing. We're going to talk about remember last week we talked about the courts and how the trial went. Now the trial's over with, and we're going into the sentencing part and the punishment that the judge dishes out. So our learning objective number 1 is to list and contrast the 4 basic philosophical reasons for sentencing criminals. And there's got to be a reason we sentence criminals, right? So let's talk about that. So the purposes of sentencing. Retribution. What is that? Retribution. That's the oldest thing in the world. It's in the Bible there. It's basically, it says, an eye for an eye. Those who commit crimes, criminal acts, should be punished based upon what they've done. Take nothing else into consideration. Just for the fact you stole something, we're going to take care of it. Incapacitation. That's a philosophy that's used a lot nowadays. That's where they prevent crime by keeping people in prison, by warehousing people. In a couple of chapters, we're going to talk more about the 3 strikes law. Actually, in this chapter, we're going to talk about the 3 strikes law, but in a couple of chapters, we talk some more about the 3 strikes law. And that's basically keeping people warehoused in jail so they can't commit crimes anymore. Deterrence. There are some people that say, hey, you know what? I probably shouldn't do that because I might get in trouble, so I'm not going to go steal a car because I might go to jail, or I shouldn't steal that candy bar because I might go to jail. So deterrence works on some folks. You look back at crime causation from chapter 2, and there's some other reasons that people commit crime, but there are some people that commit crimes by choice, so deterrence might be one that affects them. And rehabilitation. That's to bring the criminal back around so they're a productive member of society. And we'll talk about that in depth, but especially in the upcoming chapters. But rehabilitation is one of the 4 reasons we look for sentencing. We use for sentencing. It's not as effective as it could be, or maybe it should be. Learning objective number 2. We'll talk about determinate sentencing and indeterminate sentencing. So first off, determinate sentencing. Like the animations, I was playing around with PowerPoint today. Indeterminate sentencing basically says you're going to get a maximum and a minimum sentence. Minimum's going to be in a maximum sentence, but there's no specific time. In other words, it's 15 years to life, or there's 15 to 30 years, something in between there. And it all depends on how the severity of the crime, how well you act in prison, stuff like that. That's indeterminate sentencing. A lot of prisoners were complaining about that because they said, hey, you know what, I'm at the will of the jailers, and I could go in for 5 years and somebody else with the same crime can go in for 2 years, so I'd rather have this determinate sentencing. And what determinate sentencing is a practice where you get a specific time, and it can't be reduced or changed by the judges. You see that a lot in the federal courts. A lot of the federal crimes, such as, say, trafficking cocaine, would have a minimum sentence. I believe it's 10 years. But it's all based upon the statute rather than the judge that says, hey, I can be flexible on the time. Bouncing. Good time. The structure of sentencing. Good time. Good time basically means that you're going to get some time off if you behave yourself in prison. It gives the people some incentive to not act up in prison. Maybe you've seen movies, maybe you've seen stuff where prison gangs, we're actually going to show some prison gang videos when we get into the segment on prisons and jails. And you'll see that some people act up in prison gangs, stabbing, stuff like that. A lot of crime goes on in prison. So good time is the theory that, if you behave yourself, you're going to get some time off for a good time. California, it's usually 50-50. In other words, you behave yourself for a day, you get a day off from your sentence. The truth in sentencing law, that's back what I mentioned before about the federal level. That's basically what it says is, if you get sentenced to some kind of crime, or to get sentenced to a sentence, you're going to actually do some of that time. You're not going to get off the whole time because you've already done some time, or the judge likes you a lot, or the governor likes you a lot, or something like that. It basically, if it says 10 years, you're going to do 80% of that 10 years in truth in sentencing law. What are the 4 primary forms of punishment the judge has available to them? Well, it can either capital punishment. You know what that means? That means they take your life. You're no longer with us anymore. Imprisonment, just like it sounds. You're put in a jail or prison. You're kept there. Probation. We're going to talk about probation in a couple of chapters also. But probation is basically they let you go from the jail, but you're supervised by somebody when you're on the outside. You're free, but you're not 100% free. You got to do some things like maybe go to meetings, maybe check in with the probation officer. They can also fine you, take away money out of your wallet. And there's creative sentencing, and there's a learning objective towards the end here where we talk about creative sentencing. But basically that's, judge comes up with something on their own, and I'll show a couple of examples of that. Back to the creative sentencing. You can read the slide here, but basically it says in February 2012, guy was charged with domestic violence. According to the criminal complaint, he didn't wish his wife, forgot to wish his wife happy birthday, and they got into a fight, and his punishment for the domestic violence was that he had to take her out to dinner at the Red Lobster, buy her some flowers, and take her bowling. So that was a little bit of creative sentencing. And you see the thinking point questions here. Is this appropriate for domestic violence charge? I mean, this guy hurt his wife. He basically he fought with her and caused her, grabbed her by the neck. So is that appropriate? Just make a mockery of our criminal justice system? And what are some of the advantages of creative sentences? There are some advantages to it. We'll talk about that. Objective number 4. Who has input into the sentencing? If you've read the chapter, you know this. But let me talk about some of the factors of who has input into the sentencing. Basically, it's the judge and the defendant that have input into the system. Probation officers. What a probation officer does is prepares a report that says pre-sentencing that says this is why we should give this person this sentence. Maybe they've got a long criminal history. Maybe they've been a nice guy up until now. Maybe they've been a nice guy since the crime. Maybe they've got a good job. I mean, think about it. You got a guy with a good job. He's providing for his family. You throw him in jail on a drunk driving. Is it going to be very good for society? We'll actually talk about that when we talk about the going to jail in a few chapters here. But is that a good thing for society? Yeah, maybe not. Maybe it might be better to make this guy go maybe on the weekends or go do community service. So the probation officer prepares a report that says all that. The defense and the prosecuting attorneys have some say into it. The prosecuting attorney will plead his or her case to the judge saying, hey, we should have this type of sentence, and usually the defense looks for a lesser of a sentence by pointing out the good things behind his client. Remember, there's a lot of good people that do bad things on a momentary basis. And you look back at crime causation theory in the earlier chapter, I think it was chapter 2, they talk more about that. The jury. In the death penalty cases, we'll talk about the death penalty when we come up. The jury has a lot of say as to what happens to the person. I already talked about this, a pre-investigative report, pre-sentence investigative report. That's a report the probation officer prepares. I talked about that a minute ago. Went a little bit out of order here. Some of the factors, again, they look at your past offenses. They look at the seriousness of the crime. Clearly, if it's a murder, it's not something you're going to get probation on. But drug offenses, sometimes drunk driving, you see drunk driving in probation in almost every single drunk driving case. They look at aggravating circumstances. They look at mitigating circumstances. Aggravating circumstances, there's a long list of them in the book there. Did they hurt this person? It was a home invasion robbery where they beat and pistol whipped somebody, or was it a burglary where the guy climbed in the house in the middle of the day and stole a TV set? What are the aggregating circumstances? Mitigating circumstances. Did somebody steal a loaf of bread because their kid was starving to death, or did they steal a DVD player because that's what they really wanted? Who uses DVD players anymore? I bet you your grandkids will never know what a DVD player is. It's kind of like a record player. How many of you students, raise your hands? Okay, I can't see it, but have ever used a real vinyl record player? Probably not very many of you. Send me a private message if you have. And then judicial philosophy. Some judges are more liberal. Some judges are tough on crime. Maybe you've heard that on talking about, this judge is a really tough judge, or this judge is a really liberal judge, and that has a lot to do with the sentencing. And usually that's a community standard. If you live in San Francisco, they're a little bit more softer on crime than they are in where my winter home is, up in Granite Bay. Up in Granite Bay, if you're a clerk at a grocery store and you throw the change at a customer, you're going to get jail time for that, believe it or not. Don't go to commit crimes in Granite Bay. But in San Francisco, you're not going to go to jail for that. This slide shows the aggravating and mitigating circumstances. I won't pause on it too long. These slides are also available in the PowerPoint. It should be in a portable document, PDF type file, in the file right before this video. So sentencing reform. They've had some sentencing reform. Why do you think they had some sentencing reform? This looks like a happy individual. Maybe he's getting out of jail. I don't know. I don't know what his circumstances are. There's been some inconsistencies in sentencing. Maybe you've experienced it at your family level. Maybe you've seen it from friends or something like that. There are certain groups that end up going to jail more often than other groups. Different, same offense, but different sentencing. Sometimes it has to do with a lot with race. Minorities tend to get a lot stricter of a sentence than Caucasians do. Also, men and women. Next slide here talks about that. The chivalry effect. The judges are less likely to send women to jail, because they see women as the mothers of society. They wouldn't sentence their mother to jail, so they're not going to send this person to jail. The youth tend to go to jail more often than the adults, but we'll talk about the aging out in crime when we get into the juvenile delinquency thing. There are certain ages where you kind of figure out that, hey, maybe I shouldn't be committing crimes. Yay, little special effects there. You like that? Sentencing reform. One of the things they looked at was, they give the judges a lot of discretion in court. The judges have a lot of discretion to choose what they want to do in court. And basically what they said is, we're giving the judges way too much discretion. We want some consistency. We don't want the person in Granite Bay going to jail for throwing change at a clerk when that same person does the same thing in San Francisco and it doesn't happen. So they made some certain laws which are mandated. I'll go back to drunk driving because I did a lot of drunk driving arrests when I was a police officer and saw the consequences of that. Drunk driving is pretty well set. You're going to do a certain set amount of time in jail. Most of the time that's done by community service. You're going to pay almost the same fine, the same kind of alcohol school and AA meetings and stuff like that. It's pretty consistent throughout. There's not a whole lot of leeway the judge has in that. And then talk about the 3 strikes law. Several years ago there was an individual that killed a young lady named Polly Class. Her dad, Mark Class, was upset because the guy that killed her had been in prison a number of times and asked why wasn't this guy stuck in prison for life, and the judge basically said, or the prosecution said, because there was nothing we could do to keep him in prison for life. He hadn't done a lifetime crime. So what they said is, if you're a career criminal, that's what you're going to be, your livelihood, that's what you're going to do for the rest of your life, then we're going to go ahead and keep you in jail for the rest of your life. So in the 3 strikes law, basically it says 25 years to life, and we'll talk about that in a future chapter here, but they've done some reforms on that also. Excuse me. Victim impact statements. There's a video I'll put up, it's in the upcoming section here, on a victim impact statement. As a victim, they're allowed to give an impact statement at the hearings, and there's a couple reasons for that. One is it gives the victim a voice with the court, it's not always been the case. It wasn't up until the 60s or so that they started having victims impact statements and started listening to the victims and asking the victims what they wanted to do. So it gives a victim a voice before the court. It also, for the victim, sometimes is that closure people talk about. They want some closure. I don't know what that is, but it gives them that ability to maybe get it off their chest and confront whoever did this heinous crime to them or to one of their loved ones. Some of the pros, like I said, therapeutic for the victim. Judges and the juries gets to hear from the victim, so they know, hey, if I let this guy go, this is the impact it's going to have on the victim. Some cons. You know what? Sometimes it can be prejudicial towards the defendant. And remember, in this United States, we give a lot of benefits to the defendants. It's not that way in all countries. Remember last week we talked about the Japanese system of justice, a little bit different than the United States. It also brings a high level of emotion to the courtroom. In the video I've embedded there, it's a case, it's a murder case, a very famous one, and you'll see the level of emotion that's brought into the courtroom. Capital punishment. Very hot issue. In California a couple of years ago, we had an election where we were to decide whether or not we were going to keep capital punishment. The map's coming up in a couple of slides that show the states that do have and don't have capital punishment. For California, we do have capital punishment. What capital punishment is we take your life. Some of the arguments against capital punishment: cruel and unusual. There are some countries that believe that the United States is barbaric because we have capital punishment. Mexico, for instance, they're very much tied to the Catholic religion, and they're very much against capital punishment because they feel, we as humans don't have the authority to take somebody's life. So let's talk about the capital punishment, the death penalty phase of the sentencing. It's called a bifurcated phase. Bifurcated meaning bicycle, 2 wheels. Bifurcated process. It's kind of funny. It's because I have to use that term. When I worked in internal affairs, I had to use that term a lot when you talked about multiple defendants in a case. And funny how many police officers scratch their head when you say that word bifurcated. Basically, it means it's separated. So this chart kind of tells what the phases are. Phase 1, criminal trial. They have the criminal trial. You get found guilty. If you get found not guilty, of course you don't get a death penalty for that. You get found guilty, it moves on to stage 2 of the hearings. Stage 2, the jury gets to decide whether or not you're going to be sentenced to death. And they get to hear some evidence that was different in the trial. A lot of times there'll be evidence that's like, say, past convictions. A lot of times the jury won't hear about past convictions in the regular trial, but when they get to the stage, the death penalty stage, they get to hear about those past convictions, so they can make a decision whether or not this person deserves to either be put to death or to be put to life without parole. And those are the 2 decisions they can make. In California, they can make the decision life without possibility of parole or execution. The judge, that's then presented to the judge, and the judge actually makes the final decision. Yes, it's going to go to the death penalty. And we'll talk about the death penalty when we get into the prisons, but it's very seldom carried out. Actually, I think a couple of slides here we talk more about it. So what are some of the debates in death penalty states? Capital punishment, the debates they look at it, is it a deterrence? Will people not kill somebody else if they think that, hey, I've got the possibility of dying here? Fallibility, basically what that means is it 100% correct? Well, no, we've proved that throughout history, that there's been people that we've executed and later on found out, oops, got the wrong guy. Is that real good for the person we killed or their family? Nah. So it is fallible. Is it arbitrary? Some people are more likely, some groups are more likely to get the death penalty, like going back to the sentencing. Minority groups are more, and youth are more likely to be sentenced to death penalty cases than Caucasians or older folks. And that plays right into discrimination. Is there discrimination? Discrimination, again, is the outward practice of doing something wrong to somebody because of their race or religion or something like that. Here's a list of states. All the blue ones have death penalty. All the green ones have no death penalty. So you can see most of the United States has death penalty cases. Look at the Texas. I don't know if you can see my pointer on here, but if you look at Texas, 477 people put to death since 1976. California, 13. Wyoming, 1. Clue: you don't want to go to Texas and mess around. There's been a huge decline in the number of executions, at least on the state level. They got rid of the death penalty for juveniles, so if you're 16 years old and you commit a murder, doesn't matter how heinous the crime is, you're not going to go to the death penalty case. Most of the time they're putting people in jail, life without possibility of parole. It's very expensive to put somebody to death, because what happens is right away people get an appeal, and these appeals can last years and years and years. In California, it's about 22 years from the day you're sentenced to the day that you're put to death. You're more likely, most inmates on death row die of old age or disease, heart disease, something like that, rather than put to death by the state. Like I said, since 1976, only 13 people. I've actually been present at San Quentin on 2 occasions, not inside, on the outside the prison gates, doing traffic control for the people arguing for and against. So San Quentin's the only place where they have death row in California. That's up in Marin County, which is just outside of San Francisco. 2011 poll says here 61% of the people still favor death penalty. So it is popular. So let's look back over our learning outcomes for this chapter. We talked about the 4 basic philosophical reasons for sentencing criminals. We talked about indeterminate sentencing and determinate sentencing and what they're about. We talked about the 4 primary forms of punishment available to the judge. We described who has input into the sentencing decision and analyzed the factors that go into the sentence, determining a sentence. We explained why there's been some sentencing reform. We discussed the arguments for and against the use of the victim's impact statements in court. They explained the 2 stages that make up the bifurcated process of the death penalty sentencing. That's the 2 phases of the death penalty trial. And we talked about the death penalty debate. So that's it for this PowerPoint lecture. Again, you should have read the book also. There's also some videos here to show, and there's likely some homework for this chapter. There always is. How else do I assess you? How else do I give you a grade? Anyway, good luck.